Hello, thank you for joining us today. I'm Cedric Burton. I'm a partner at Wilson Sonsini Corporation Rosati in the Brussels office, where I'm the co-chair of the firm Privacy and Cybersecurity Practice. I'm joined today by my colleague Laura Leitner, who is of counsel in our London office, and we are going to discuss the implication of Brexit and the steps that companies should consider taking to prepare for it. So today we're gonna follow the following agenda. We're going to do a very brief introduction about what is Brexit, how Brexit and GDPR deal with each other, so what's the relationship, what's the current situation, and how Brexit will impact your businesses. And for that, we're going to look at a number of specific topics, namely data transfer with a slight focus on BCR, the main establishment concepts, what needs to be done with the privacy notice, the impact of Brexit on the legal representative, and then a couple of issues to finally conclude by how can you, practically speaking, prepare for Brexit.
So we'll start off with the question, what is Brexit? You will probably all have heard about Brexit, but we just want to give you a quick summary because I think it's helpful to give you the background. So Brexit is the withdrawal of the UK, the United Kingdom, from the European Union. Brexit is scheduled to take place on the 29th of March in 2019, so that's in about 9 days, at 11 p.m. UK time, so midnight in Europe, unless the EU and the UK agree some kind of extension to the Brexit period. And I'll go into further detail on that in the next slides. You will have heard stuff about deal Brexit, no deal Brexit, so we're quickly going to explain what that is. A no deal Brexit is basically where in 9 days the UK exits the European Union and there's nothing in place, no trade agreements, no arrangement to no fallback. There's just a complete stop in the applicability of European law in the UK. That is obviously not a great scenario, so that is why the UK and the EU are trying to talk about reaching a deal, and the deal would include some sort of transition period of about 20 months during which the EU laws will still apply, but the UK would technically already stop being part of the EU, and this would give the parties a bit of time to prepare for the actual end of the transition period. Could we go to the next slide? So the next slide shows the actual timeline. So what happened is the Brexit vote took place on 23rd of June 2016. The UK then had to prepare to invoke Article 50 of the European Union legislation, which Article 50 is the article that allows you to actually exit the European Union. It has never been used before, and it gives you a 2-year period, a 2-year notice, basically. And then that was triggered the 29th of March 2017. And on 19th of June, the UK and the EU started their Brexit talks. So basically, the parties have been talking about this for a long time, trying to reach a deal. And on the 25th of November, they came up with a draft withdrawal agreement. The draft withdrawal agreement had some sort of transition period in it. And as things go with any type of deal at that level, they need to be approved by both parliaments, go through the whole legislative process. There have to be, implementing acts. So basically, what the UK did on the December 11th is they proposed it to Parliament and they voted it down. So the UK wasn't happy with the contents of the withdrawal agreement. So between December and now, the UK and the EU have been trying to reopen the withdrawal agreement, the draft, and talk about things that should change, could change. You will have heard in the news things about the Irish backstop, stuff like that. It's not relevant for our discussion today, but at the end of the day, what it looks like is that we will not have a deal by the 29th of March. So either in about 9 days, we'll have a hard Brexit, a no-deal Brexit, or the UK and the EU need to reach an agreement on a possible extension, during which they can continue negotiating. And the extension hopefully results in a new withdrawal agreement and a new transition period during which we can all prepare, ease out of the EU. So that is the background. Now, how does GDPR play into that? GDPR is obviously a piece of European legislation. It governs data protection, and it came into force in May 2018. So it was voted in May 2016, and then all the countries got 2 years to start preparing for it. In May 2018, when it became applicable, the UK was obviously still part of the EU, so the UK had to implement the GDPR, and that's what it did. And that's why we have the Data Protection Act 2018 in the UK, which completely copies the GDPR, except for a few minor provisions. So currently, the UK, all businesses in the UK or all businesses dealing with the UK have to deal with the GDPR. After Brexit, this means that the UK data protection legislation will still be based on the GDPR. It'll still be exactly the same at the moment of of Brexit, and then it may start to diverge depending on how we go forward. The parties are discussing as part of the whole withdrawal agreement and about the part of the whole data protection. There's an aspect of the discussion that's about data protection. Obviously, they're discussing about the UK getting adequacy, which means that we'll go into further detail when we discuss data transfers, but basically which means after Brexit, the UK would be seen as a country that protects data in the same way as the rest of Europe. However, currently obviously it's the case because the GDPR is applicable in the UK, but as it looks now, if we have a hard Brexit, that won't be the case, and we've got a number of issues that we have to deal with.
So let's move on now in the concrete impact that Brexit will have on your business. The main one really deals with data transfer. So just to level set a bit here, what's a transfer? A transfer is quite a broad concept. It includes, of course, if you have a database let's say in the EU, and you do send that database to the US for storage or for backup purposes, that's a physical transfer of data, and that's pretty clear. Generally speaking, any flow of data between countries is considered to be a data transfer. And I said that it's a broad concept because it does cover things like remote access. So if you have situations where the data are stored in the EU, but they are accessed by an IT team in the US or in India, that remote access to the data, is even simply viewing the data without being able to modify them, is typically considered to be a transfer under EU data protection law. So in today's economy, you do have data transfer on a daily basis, on a regular basis. Data flows constantly among different regions. So of course, as Laura explained, the UK living is going to have an impact because under EU data protection law, and it was the case in the past under the directive and still the case under GDPR, we have a general rule which basically prohibits data transfer outside of the EU, except if the country where the data will be transferred is considered to provide an adequate level of protection, which basically means having essentially the same level of protection provided to the data than what we have in the EU. So that's quite a high bar, and there are very few countries which have received adequacy so far, and the US is not part of them. Now, what's the link with the UK? It means that once the UK leaves the EU, it's going to be considered a third country, and any transfer of data to the UK would be basically prohibited because the UK, even though it would have the UK Data Protection Act, which is pretty much a copy-paste of the GDPR, has not gone through the adequacy process with the EU Commission, which is a pretty lengthy process during which the EU Commission is going to look at the law which is applicable, how it's enforced, and it's going to look at issues like national security as well. That's why we had a lot of discussions and case law about that specific issue with the US in the past, and the whole Schrems case issue with the safe harbor framework. You could expect to have a similar debate with the UK. The UK being part of the Five Eyes. I think some people in the EU are going to raise similar issue with the UK than with the US. That's a bit controversial, but my point is that even though the UK will be trying to seek adequacy, it's going to take a bit of time for them to get it if they do get it. So, basically prohibition of transfer outside of the EU. The UK is not going to be part of the EU. Therefore, that means that any transfer to the UK will be by default prohibited unless you implement a data transfer mechanism. And we're going to go through a number of different hypotheticals now, but basically you have a number of tools available. One is Privacy Shield. It's only available for US companies because it's something which is enforced by the FTC. So it's a self-certification scheme which is basically maintained by the US Department of Commerce. It's a scheme by which you agree to abide by 7 principles which are based on EU data protection law, and you need to make some public disclosures about these principles. And then if you don't comply with this disclosure, the FTC can go after you under Section 5 of the FTC Act. So that covers transfer to the US. Next to that, you have the standard contractual clauses, which are the SECs or model contract. There are template agreements issued by the EU Commission, which needs to be concluded between an entity in the EU exporting data and an entity outside of the EU importing data. And if the two parties conclude that agreement, the data recipient, the data importer, is able to receive the data lawfully under EU data protection law. The third mechanism which is available is what we call binding corporate rules, which is basically a code of conduct which is made binding on a group of companies. It's the most sophisticated and most difficult mechanism to implement. It needs to be approved by now what is called the EDPB, which is the body which includes all EU data protection authorities in the EU. BC are allowed to transfer data within a group, but it does take time to implement that. So this is the third mechanism. Very briefly, the GDPR allows to use code of conduct and certification scheme. These mechanisms are new in the law. They have not been used yet. It still needs some work from the regulator. There is no certification body yet. There is no code of conduct approved. There is quite some work in progress in respect of these two topics. They are not really available right now. And lastly, you have the exception or the derogation, which include consent or execution of a contract. So, for example, if you book, if you reserve a hotel in the US, you need to provide some information to make the booking, and typically that will fall under one of the exceptions if the data you provide is really limited to what's necessary for the booking. So that's really the framework. Now let's go through some hypotheticals. So the first one is you have a transfer of data from the US to the UK. That one is easy. There is no change. I mean, you need to comply with the US law. And in most situations, there is no data transfer restriction. So you can freely send data from the US to the UK. Two caveats to that. One is if you are Privacy Shield certified. So typically you would receive data from the EU. You have done a Privacy Shield certification. There is a principle into the Privacy Shield framework which prohibits you from sending data to another party unless you comply with the onward transfer principle. So just something to flag when I say there is no restriction in the US. It's not true if you are Privacy Shield certified. The second one too is if you receive data from the EU under the model contract, any further transfer or onward transfer of data from the US to the UK would be captured by the onward transfer principle into the SECs, the standard contractual clauses. So, at a high level, no restriction on data transfer from the US to the UK, except if you receive data in the first place from the EU, in which case, depending on what you have in place, you might have restriction on further transfer of data to the UK. Now, let's look at the opposite scenario. You basically have a transfer of data from the UK to the US. There, the UK rules are going to remain the same. So it's going to be the UK Data Protection Act of 2018, and that's basically a copy-paste of the GDPR. So two main options: Privacy Shield, which explains the self-certification scheme. Relying on the Privacy Shield for transfer of data between the UK and the US is going to require some changes to your Privacy Shield certification, which are actually pretty limited but are important to make. So typically, the Privacy Shield is really an agreement between the EU and the US, or Switzerland and the US. and the U.S. Department of Commerce has been issuing recently an FAQ about what would happen with Brexit. And the key takeaway is that they say that the agreement between the EU and the U.S. could be relied on for transfer between the UK and the US, provided that companies update their certification to make the disclosure that data will be sent from the UK to the US. That may be valid for the customer data, so modifying the online privacy policy to make that statement. That will also be valid for HR data, so if you have data from employees in the UK and you send them to the US under the privacy shield, you will have to make some new disclosure into your HR privacy notice about that transfer. Two other points important to keep in mind with the privacy shield: you need to recertify every year. So you need to look at when you certified in the first place, and you need to maintain certification. If it elapses, you are not covered anymore, and so you would end up in violation of the UK Data Protection Act or of the Privacy Shield. And then there is an obligation to cooperate with DPAs, EU DPAs, data protection authorities, if you transfer HR data or if you voluntarily decide to select the EU DPAs as the enforcer of the Privacy Shield certification as the recourse mechanism for EU individuals. And if you do select EU DPAs, EU data protection authorities, it's going to be understood as including the UK Information Commissioner, the UK ICO, as being the DPA responsible for exercising recourses for UK data subjects. So that's the framework for the Privacy Shield. Model clauses, SECs, they stay valid as they have been so far. Just one note on that: the current SECs. You have three versions of them. One is controller to controller from 2001. Another one is the controller to controller transfer from 2004. And then you have a controller to processor version of 2010. These SECs have been prepared and approved by the EU Commission under the directive, but the GDPR provides that they are still valid as a data transfer mechanism until they are amended or repealed by the EU Commission, which has not happened so far. So whatever has been done under the directive is still valid. These tools are still valid. It's clear that there is some tension around them because they are being challenged before the European Court of Justice, and before there is work to do on the EU Commission side about updating them to align them with the GDPR. But for now, SECs are still a valid tool. Last point: derogation, consent, execution of a contract can be used in exceptional cases. Now, let's look at transfer between the EU and the US. It's a status quo. The main change there is that the UK is not part of the EU anymore. So if, within your data transfer strategy, you were thinking, about the UK as being part of the EU, that needs to change. So that's really the bottom line. That may have an impact on, the contracts or your internal documentation or any places where there is either an authorization to transfer data or where you actually need to document all the data flow. In the past, typically, you would have said authorized transfer to the US. Now you would have to authorize transfer to the UK. Or if you were dealing with only authorized transfer within the EU, just be mindful that the UK will not be part of the EU anymore, and so you will have to have a specific authorization for data transfer to the UK as well. Next one, UK to the EU. That's an interesting one. The UK government has been quite practical on that point, and has been saying, well, from our point of view, the EU is going to be adequate because we have the same law, so data will be able to free flow from the UK to the EU, which is a practical interpretation of the law, and is going to facilitate the exchange of information between the UK and the EU. Just be mindful that some UK data controllers may be willing to take a more conservative approach and still require some data transfer mechanism to just anticipate potential issues or tension between the UK and the EU, or to take a very safe approach on this issue and don't take any chance and avoid to go back to customer every time there is a change. There is a lot of uncertainty in that field, and that's generally true when it comes to data protection law. So you do see very large players sometimes taking a rather conservative approach and applying the highest threshold as a way to minimize cost and back and forth, in particular when it comes to contractual issues. And now the next one, which is the last hypothetical here, and then we are going to go through 3 examples, is transfer of data from the EU to the UK. And, as I said here, the UK is going to be a third country. So basically any transfer of data from the EU to the UK is going to be prohibited. That would be valid as of the date of the no-deal Brexit, so the hard Brexit. So if there is no agreement on March 27, any transfer of data, any transfer of data between the EU and the UK will be prohibited. Could be sanctioned by very big fines under GDPR. So that's one scenario. The second scenario would be, which seems to be the one towards which the UK is going now, if there is an extension of negotiation time until end of June, then we're going to have a status quo, and that's what the UK is trying to negotiate with the EU at this stage. It's just out today in the press. The third one is if there is some kind of agreement reached by a deadline. It could be in March, could be in June, could be the withdrawal agreement, very likely, or the modified version of it, or some kind of other agreement. In that scenario, it's likely that there will be a transition period in place, which means that during that period of time, the UK would still be considered to be part of the EU from a data protection standpoint. There is a willingness from the UK to receive an adequacy decision on time. It's a very lengthy process. It's not something which happens overnight. It typically takes years to receive adequacy from the EU Commission. As you can imagine, it's a very political process. And in the current state of affairs between the UK and the EU and all the trade-off and negotiation which are happening at this stage, it seems very likely that the EU Commission will hold the adequacy as a bargaining chip against the UK. So I will not hold my breath on adequacy, and that's something which is going to be heavily negotiated in the future. On hard Brexit, no adequacy, model contract is the way to go, or derogation, which is as well the other option. But basically, like the SECs and the model contract seems really to be the way to go between the EU and the UK. So with that and a lot of information, I'm going to let Laure go over like 3 concrete examples, and which illustrate basically what I explained over the last 15 minutes.
Yeah, because we understand that obviously a lot of data transfers are quite complex. So they do often involve more than 2 parties. They go from one to the second to a third to even a fourth. So a first example that we wanted to call out is where you have a EU controller, which is usually a customer. They are sending data to an EU processor, and that's a service provider. And then the data gets sent on to the UK. So previously, pre-Brexit, this wouldn't have been a problem. All of this would have been in Europe, and you wouldn't need any type of data transfer mechanism. However, after Brexit, you are now faced with a data export or data transfer between the EU processor and the UK sub-processor. So usually it's a subcontracted branch of the UK, the service provider. Now we've got a problem there is you can enter into intra-group model clauses between the EU processor and the UK sub-processor because there's no such things as processor-to-processor model clauses. We may have, heard about them being in the works, but up until now, there is no such thing. So what, in principle, you would have to do is you will have to put in place model clauses between the EU controller and the UK subcontractor directly. So these are two parties who will not be, they'll not be part of the same contract initially, but you'll have to like establish a contractual relationship that goes directly. And that will solve the problem. We understand that and this is something that, we'll see what happens on a hard Brexit or on a transition. But this takes time. You'll have a lot of existing customers. You can't just, you may be able to send out a letter and say, all these EU customers need to all of a sudden sign up to the agreement. But from what we've learned from the GDPR, that's actually quite a lengthy process. And therefore, the sooner you can start with it, the better. However, taking into account that there's no clarity, it's a bit unclear when clients actually need to start working on this. Hopefully we'll know more, in the next 10 days.
So on that issue, like the cleanest one is to have a C2P basically between the EU controller and the UK sub processor. And a potential alternative is to include a mandate into the agreement between the EU controller and the EU processor, by which you would authorize the EU processor to subcontract on your behalf and sign on your behalf with the UK sub-processor. The issue there is that if you already have an agreement in place between the EU controller and the EU processor, it might be easier actually to just subcontract with the sub-processor. It depends a bit on what the EU processor will do in that scenario. So you could see the service provider going back to all its customers and saying, look, Brexit happened, this is an issue for you, and this is what I suggest. Give me a mandate, I'm going to sign on your behalf. That would be a nice way to solve it from a business standpoint. If the service provider doesn't do anything, first it would be in breach of the law, but then as a controller you would have to do something about it, which probably means, going to the processor directly. So, even in one specific case, I think there will be different options depending on, whether you're the controller or the processor, what you want to do about it, and the level of risk you want to take.
Yeah, and I think an additional comment is that often where parties were contracting in Europe, they obviously, no one felt the need to call it out in contracts where they're working with the EU branch, because previously it was all, so you have these blanket approvals, whenever subcontracting happens somewhere in Europe, you're fine, and they don't call out UK specifically, so in a lot of cases the EU controller might not even be aware that the UK is involved in some sort of way.
So next one.
So in the next scenario, we've got we've lined up another few countries. So basically, you've got a customer who's based in Europe, and they use a US processor, so a service provider in US, and the US relies on a service provider in the UK as a sub-processor. This can be same group or an external one. So you've got three parties involved, and there, what you do is you look at each transfer specifically. So you can, because the US is involved, we need to discuss this under Privacy Shield first, and then look at the scenario using model contracts. So first, if we imagine that the US processor is Privacy Shield certified, the EU controller can send all of its data to the US, and then as we previously discussed, the US processor will need to carry out an onward transfer to the UK, because they're a third country. This is quite a clean solution. Most US processors who are Privacy Shield certified will have onward transfer agreements in place with other entities, so they'll just need to work on putting those in place with their UK subcontractors or sub-processors. In a second scenario, where the US processor is not Privacy Shield certified, you'll have to work with the model contracts. So what will happen is the EU controller will enter into controller to processor model contracts with the service provider in the US. And these model clauses, they have a provision in there that says that whenever the processor is working with subcontractors, these subcontractors can sign up to the same agreement or have to abide by similar rules. So basically you would sign up to an onward transfer agreement, which basically mirrors the controller to processor model clauses. This is not a difficult scenario to solve.
And actually that's a scenario which is quite common for US service providers. So if you're a SaaS company or any kind of service provider and you have EU customer, it's not unusual to have a branch or to have a bunch of engineers or some development guys sitting in the UK or somewhere in the EU, but like that happens quite a bit. We do see that in practice among the Wilson client base. That's something which comes up on a regular basis. So it may look a bit artificial, but that's really based on real life example. And the good news is that there are ways to cover that scenario.
Okay. And then we go to a third scenario, and I think a lot of this is quite a hypothetical one. You've got a UK controller who's sending data to a EU processor, and then they receive the data back. So the transfer between the UK and the EU should ideally be subject to model contracts, but as we've discussed before, because the UK government has confirmed that they will not be taking action because they consider the EU to be adequate, there's actually nothing that needs to be done. So unless the UK controller is a highly regulated or very risk-averse controller, you'll probably not do anything in that regard. However, the transfer going back will then be covered by the EU data transfer rules, and the EU processors are also subject to those rules. So then there's a question, what do you do? Because you've got a EU processor sending data to a UK controller, but there's no such thing as processor to controller model clauses. So this causes quite a headache, but if you think about it, at the end of the day, the data originates in the UK, goes to a country with an equivalent level of protection, and then goes back to the UK. So the level of risk is quite low. However, if you want to be fully compliant, you'll have to look at what you can do here. And we've discussed this a bit internally. And the way to solve this is, as a UK controller, you have an obligation under the GDPR to enter into a written agreement with your EU processor. And as part of the requirements relating to that written agreement, there's a requirement around making sure that any export of data is adequately covered. So what you'll be doing is you'll be setting up an agreement between your UK controller and your EU processor, which doesn't just cover the instructions on data handling, but also covers the transfer, even though the transfer in the end goes the other way around. So, yeah.
So these are like three, concrete scenarios that we do see on a regular basis these days. If you think of particular scenarios that you'd like us to discuss, or, we realize that that's quite a bit of information. So if you have any questions, feel free to use the Q&A section of the tool and ask questions. We'll take them at the end of the presentation. Now I will move on to the next topic, which is technically part of data transfer as well. It's binding corporate rules. Binding corporate rules need to be approved by the EDPB, the European Data Protection Board. The UK Information Commissioner, the UK ICO, is part of the EDPB. So basically, when you want to get your BCR approved, what you need to do is you need to go to your lead DPA, which in a nutshell is the DPA of your main establishment in the EU. You have some negotiation with your lead DPA. Once the lead DPA feel that the BCR are good enough and comply with the requirements set in the GDPR, it does go to the European Data Protection Board and propose present the BCR to the other DPAs. I spare you the details of the procedure, but basically after a certain period of time, the BCR is approved by the EDPB, which means that it's valid throughout the EU. Now, if the UK or when the UK is going to leave the EU, the UK ICO, the Information Commissioner, is not going to be part of the EDPB anymore, which means that it's not going to be involved in the process of getting the BCR approved, which means as well that it cannot be your lead DPA because it will be outside of the EU. Concretely, you need to differentiate between three different scenarios. The first one, which is the easiest one, is you have not your BCR approved yet. In that context, your UK company or your global multinational company with your main establishment in the UK you cannot pick the UK ICO as your lead DPA for BCR purposes. So basically, you need to look at other countries and identify your main establishment in the EU, so the current EU minus the UK, and start the procedure with, the French CNIL or, the Spanish Protection Authority or the German DPA, for example. And you need to do that in light of what's laid down in the GDPR and in the DPB guidance. So basically, you will need to pick a DPA outside of the UK. Current BCR application is a bit trickier. Basically, it's a BCR approval is a process. So you reach out to your DPA, you start negotiating, it takes time, there's back and forth, it's a written process. At some point, there's an approval, you go to the DPB. If, you have not had your BCR approved yet, on the date of Brexit, and if you have the UK ICO as your lead DPA, you would have to pick another DPA who would start the process again. So we initiate a new procedure, go back and forth with you. There are sometimes differences depending on the DPA which act as the lead, and then we'll have to resubmit a draft decision for the BCR to the DPB. So, we will not have to start from scratch. We expect DPAs to be relatively practical about this, but there are some differences in interpretation and in what DPAs focus on depending on who you talk to. So, the UK tends to be very practical. Other DPAs tend to be a bit more conservative in their interpretation, so that may have an impact on your actual BCR. Last scenario for binding corporate rules is you actually have approved BCR, your BCR were approved by the ICO, everything is in place, that's fine. What you need to do is to identify, another lead DPA in the EU, and when you need to update the BCR, or if you need to for whatever reason, modify them, you would have to go to that new DPA in the EU. Next topic is the main establishment. So that's a key point in the GDPR. The GDPR basically allows companies which operate at a pan-EU level for cross-border activities to deal only with one DPA. I mean, there are a lot of nuances to that, but that's the overall concept. You have a one contact point to interact with, which allow you to build relationship and to increase awareness about your practices with an authority. So that's one of the great things with the GDPR. Once the UK leaves the EU, if the ICO is your lead DPA, you will have to start the process again and identify your lead DPA. So where is your main EU establishment? And start building relationship with that new DPA, who will then be acting as your contact point for a number of issues. But on the flip side would also be the entity or the authority fining you if you are in breach of the GDPR. So very important to raise awareness with that authority, to get familiar with them, to establish a relationship, so that they know about you and what you have in place.
Another thing you will need to look at when you're dealing with Brexit is you'll have to review your privacy notices. This is not the most exciting part of the job, but it will need to be done. And it's quite simple actually. So you'll have to pull up all your internal and external privacy policies, and you'll have to look at all the references to the European Union, the European Economic Area, and the UK, and just make sure that they make sense. Your privacy statement should, if it's been GDPR approved, include a section on data transfer mechanisms, which you will want to update to reflect however you've solved your data transfer situation after Brexit. And then if you're Privacy Shield certified, and this is what we've discussed before, you will need to update your commitment, which is part of your privacy policy. An example of that can be found on the Privacy Shield website in the section on FAQs about Brexit. Ideally, you prepare all your documentation prior to Brexit. This is either, at the moment of a hard Brexit, so in about 10 days, or the documents will need to go live at the end of the transition period. Something just to think about is you need to consider what your rollout requirements are. You can't just update. I think this is quite a big change to a privacy policy, so you'll have to see what your section on changes says. and whether or not you're going to notify users of material changes and then comply with that. You may have followed that process before for other changes. Another thing you may want to look at, and I don't know how many of our clients are dealing with this at the moment, but you may have a legal representative, or you may not have a legal representative and may need to appoint one. So there's this table sets out all possibilities, but basically there are the three main situations that you'll need to consider. The first is you're established only in the UK, and after Brexit you will offer goods and services to the rest of the EU as well, or monitor EU users. In that case, you will keep your UK establishment, but you will also need a EU representative. You'll need someone on the ground in the EU who acts for you locally and is a contact person for the authorities. Then the other scenario is where you're established in Europe, and after Brexit, you offer goods and services to Europe, but also to the UK. In that case, you need to keep your European establishment, but you need to also appoint a UK representative. And then in a third scenario, you're established in rest of world only, so not in Europe and not in the UK. In most cases, this will be you will be established in the US. And after Brexit, you'll have to look at where you offer goods and services or monitor users. If this is only in the EU, you need to appoint a representative in the EU. If this is only in the UK, you need to appoint a representative in the UK. And then if it's both in the EU and the UK, you will need to appoint a representative in both countries, in both locations, so both in the UK and in the EU.
I think the legal representative obligation is something which is sometimes underestimated.
Yes.
And we expect to see regulators, focusing a lot more on that. Interestingly, that obligation existed in the law since 95, but has been out there for for 20 years, and there was little enforcement on that. Now, we do see a trend in practice, and more companies are actually appointing a representative, and we do see DPAs looking into that, and that's particularly relevant for US companies which start to sell in the EU or the UK and are expanding in Europe. That's something to keep in mind. Now, talking about a few other points, to keep in mind with Brexit, and then we'll have, gone around what are the key topics to think about when Brexit will happen. The first one is accountability. So accountability is a key principle under GDPR, and basically it requires you as a company to maintain a lot of internal documentation which describe your data processing activities, and as well to create a bunch of internal procedures and processes. And the hook is that that's something that as a company you need to be able to show to the regulators if there is an issue. And what we have seen since May 25th, 2018 is that when there is a complaint, when there is an issue, regulators ask to see it. They ask to see the Article 30 internal records. They ask to, we can call that data maps or data inventories, but it's the same idea. It's really like internal documentation about your processing activities. It's all provided by the GDPR. And when you don't have that as a start, it's quite difficult to move along. So it's very important to do that as a company. Now, in these internal records, you need to mention where the data are stored, and you need to put some information about data transfer. So you may have to update your data maps to make sure that they are accurate and that they reflect the fact that the UK is not part of the EU anymore. Linked to that, there is what we call the obligation to do a DPIA, data protection impact assessment. That is a bit more hypothetical, but you could think of situations where you have done a DPIA because you are within one of the situations where regulators believe that a DPIA is required, which means that your processing is likely to trigger a risk or a high risk for individuals' privacy. In that scenario, you need to do a DPIA, which is basically a risk assessment, which balance the safeguards you put in place the risk for the individual's privacy, how will you mitigate that, and hopefully you end up in a situation where the risk is not high anymore, and then you can go ahead. If the risk is still high, you need to consult with the DPA. If in the DPIA you talk about data transfer, if that's an issue or something which is a focus of your DPIA, you should have a look at them and make sure that they don't need to be updated or that no new risk is being triggered. Last point, which is linked to the accountability, is in the GDPR there is an obligation to appoint a data protection officer, which is different from a chief privacy officer. So a CPO is different from a DPO. A DPO is basically the long arm of the data protection authority. There are some requirement and guidance from regulators on where the DPO should be located. If your DPO is in the UK, it may not be the end of the story. You may have to think about, what will be the impact of Brexit on your corporate structure, on your privacy governance structure. You may have to relocate the DPO. You may have to appoint local, DPOs to cover some, EU countries. So that's something to keep an eye on as well. Is how does Brexit is going to impact your data protection governance program and how you actually supervise it, in the EU and beside. Last point, which is maybe a bit more theoretical, but is going to have a very big impact on companies. In the long run, we expect to see differences between the EU and the UK when it comes to data protection. So in the past, and there were the directives which provided for less harmonization, there was quite some differences between UK law and, let's say, French or German or Spanish law, the UK being on the most flexible, side of the table, and the others I mentioned being more on the more restrictive, the regulators in the EU. The GDPR increased the level of harmonization. Unfortunately, it doesn't bring full harmonization, but we do expect to see, some divergence in interpretation, for sure, and that's how it goes. At some point, there will be amendment to the UK Data Protection Act. There might be new legislation in the EU, like the e-privacy regulation, or sector-specific legislation coming up, which is going to complement or derogate to the GDPR. And at that point, we're going to see some differences between the EU and the UK. So something to keep an eye on. That's going to be aggravated by the fact that the UK ICO is not going to be part of the EDPB. The UK is trying to negotiate an observer type of role to still be involved in the discussion, to at least be aware of what's going on. The EU Commission is really against that and giving a huge pushback. It's like if you leave the EU, you're not part of it, full stop. But that's going to have an impact on both the way the law is going to be interpreted, but as well about how the law is going to be interpreted in the EU. So the UK ICO is known to be the most practical regulator, with maybe the Irish DPA, and the UK is a big country, so their voice is heard. Not having the UK at the table is going to have an impact on the discussion and on the balance of power within the EDPB, and we could expect to see some slightly stricter interpretation happening in the future. Court of Justice of the EU. That's the highest court in the EU. That's the one which issued the Costera case, the right to be forgotten case against Google. That's the court which invalidated the Safe Harbor framework. That's really like the highest court in the EU. The UK is not going to be subject to it anymore, so the UK Supreme Court may be taking diverging position when it comes to data protection in the future. And last but not least, you're going to have a double fine system. So far, there are some exceptions to that, but when you have a pan-EU issue, you have one fine which is issued by the lead DPA. UK being out of the EU, that means that you're going to have one EU fine and one UK fine, which will be both potentially very, very, very high. So that's something to keep in mind. So it does increase the risk level, generally speaking, in Europe. Now, to wrap up, how can we prepare for it? Well, the first thing to do, and I think the main issue, or like the highest risk issue, is really the transfer point. So, typically what you do is you first try to figure out when there is data processing activities in the UK, and you should pay attention to data transfer issues. So when data will be sent to the UK, and when data will be leaving the UK to the EU or to the US or to another country. Once you have a good overview of your data flow, you need to look at you need to look at the different options and see what's the best data transfer mechanism. Most likely to use a lot the SECs, except when you have a transfer between the UK and the US. If you have a privacy certification, or even if you don't have, looking at the privacy shield as an option is very practical. So SECs or model contract are probably the way to go. If you have BCRs, you're going to rely on them, but that's basically in a nutshell the summary. Then look at your internal records, data maps. Make sure you document everything you do. In that bucket, I would put the contractual issues. So, a lot of companies spend a substantial amount of time reviewing contract with service providers and sub-processor when you're a controller and when you're a service provider with your own customers. And most of the time, there is a clause in it which authorizes data transfer to some countries, to all countries, or which prohibit data transfer, outside the EU. In these three scenarios, you should look at what's going on in your contract and make sure that transfer to the UK will be allowed if that's something which is happening. The UK being out of the EU and the reference to the EU will not be enough anymore moving forward. Another point that Laure mentioned, privacy notice. There are some disclosure to make about data transfer, about the UK. And then the last one, which is all linked, is like the lead DPA, BCR, and the legal representative issue. So it's more on the regulatory side. Make sure to anticipate Brexit and see what would be the impact on that. So with that, we're going to take a few questions. So the first one, I think, which is probably like the one that everyone has in his mind is like, okay, let's assume Brexit is in 9 days. We have not done anything yet. What should we do now? Where should we start and what should be the highest priority? Laure, you want to take that?
I think, we all know there's a lot of political uncertainty, and I think to be on the safe side, we can assume there will be uncertainty right up until the end. So the best way to go forward is to start preparing your internal documentation. Make sure you've got the necessary template contracts, model clauses in place. You've looked at the transfer mechanisms, how your company would comply with them. You have updated privacy notices stored on your computer. Just keep them saved, and then whenever something happens, just to make sure you can basically take action immediately. It's not ideal because this means that wherever you're faced with a customer rollout or a rollout of an updated privacy, there may be some delay. But in any event, you can show that as a controller or a processor, you've taken the necessary steps to comply with the GDPR and the UK Data Protection Act.
Yeah. Next question. Do you think there will be a grace period? Assuming there's a hard Brexit on March 29, are DPAs going to, enforce as of March 30th? Or is that would there be like 3 months or 6 months, grace period?
I think based on our previous experience when Safe Harbor went down and everyone was scrambling to see what was going to be next, there was indeed a grace period of a couple of months, and I think we all expect there to be something similar, but you cannot rely on that, and I think that's why, coming back to the first question, you'll have to make sure that you have your documents in place and you're doing whatever you can to prepare, even though that means on the day of, Brexit, may it be a hard Brexit in 10 days, you'll still have a minor delay in rollout.
Yeah, I think with the Safe Harbor framework, what we have seen is that DPAs have been like on October 7 or like just after the Court of Justice case, came out, decision came out, like the DPAs have been giving like kind of formally, some unofficial like grace period saying, look, you're gonna meet again in January, and companies must comply by then. The rationale was nobody really knew where the court would be going, and I think a lot of people were really taken by surprise. So there was a grace period of 3 months, which created a huge rush into model contract. Here, what we have seen is we have seen statements from the EDPB or from the CNIL saying, well, that's all great, but everyone knows about it for 2 years. So, from our point of view, there will not be any grace period. So they're taking a pretty hard stand on these issues. Now, to Laura's point, practically speaking, it seems unlikely that they're going to start enforcing, on April 1st. But who knows? If you get in trouble for whatever reason and you didn't cover or didn't try to cover Brexit, that may just be an aggravating factor for the regulators. Then last question, and then I think we're gonna run out of time. Basically, we have a question about we're based in the EU and Ireland. Data is backed up in the UK. How do we cover transfer of our own data between the EU and the UK? Just a disclaimer that doesn't constitute legal advice, but basically you're in the situations where you're in the EU because you're a data controller in Ireland or a service provider in Ireland, and your data is going to go to a third country. So if you're a controller and you use a service provider in the UK, it's relatively easy. You do a C2P model contract, the C2P SECs, which will cover the transfer from Ireland to the UK. And then, since the UK is going to be a service provider on your behalf, you will be able to get the data back. Now, if you are a service provider in Ireland and use a sub-processor in the UK, then it's slightly more difficult, and that's one of the scenarios we dealt with today. It means that you need to be authorized by your controller, by your customer, to use a sub-processor outside of the EU, and that may mean you need to go back to them and try to get their authorization and mandate to sign the C2P on their behalf, or you need to reach out to the customer and ask them to sign an agreement with, the backup entity. And I see we have 2 minutes for our last question. If you were able to make the case for your main establishment being in an EU country, what way would you rank the regulators in order of being pro-businesses? Well, so first of all, there are criteria in the law, about how to select your main establishment. So it's not pure forum shopping. It's not, you just not pick and choose who will be your main establishment. Now, if I look at DPAs, which are the most practical in the EU, I think our experience here is Ireland tends to be quite practical, which doesn't mean that they don't enforce. A lot of IT companies are based in Ireland, or if they're EUHQ in Ireland, they have a lot of cases ongoing. They have a lot of experience dealing with companies, but they are not to be underestimated. They really staffed up their DPA, but it's true that slightly more practical when it comes to the protection law. The UK was part of that group, now leaving. I would probably look at the Nordic countries then, who tend to be, slightly more practical. And then I would say that I would put, the Dutch DPA, the Belgian DPA, as being relatively business friendly. And on the other spectrum, I would put the southern countries, the Italian, the Spanish, the French. Some German DPAs are quite restrictive, not all. Poland tend to take a hard stand. So that's at a very high level how DPAs are, quote unquote ranked within the EU. So with that, we're running out of time. I'd like to thank everyone for participating. Again, the recording is going to be on the on-demand learning portal of the firm. And I want to thank Laure for participating today. And thanks everyone for listening to this webinar. Thank you.